Good morning, everybody. This is the beginning of week 7, which is our next to last week. And it's maybe the biggest week in the whole term because it's the week your final project is due. Please don't think that the final project is due in the final week. It isn't. It's due this week. Now, I want to say a couple of things about the final project before I start talking about the subject of this week's academic news, which is civil litigation. But the final project requires a great attention to detail, and it particularly requires that you follow the grading rubric. I know I've said that over and over again for the milestones and for some of the short papers, but for the final project, it's really crucial. The grading rubric is long. It has a lot of elements in it, and I have to grade you on every single one of those elements. So my very, very strong suggestion to you is that you not only read the grading rubric, but that you print it out and have it beside you as you write your project. Because if you don't, it's so easy to miss one or more of the elements of the rubric, and you have to get a 0 for things that you don't address in your final project. I know I'm harping on that a lot, and I'm doing that for your sake. I don't like to give you zeros, and I'm pretty sure you don't like to get them. So please, let's try our best to follow the rubric step by step, even if you think it's a little disjointed, because it is, and just address all the elements in the rubric, even if you think it makes for a narrative paper that doesn't meet your standards of how a paper should flow. It almost certainly will end up that way because the topics really don't always flow together very smoothly. Don't worry about that. You're not being graded on that kind of writing style. What you're being graded on is the content and the fact that you have actually answered all of the elements of the assignment. So again, please follow the rubric as you write. If you are already in the midst of writing your final project, and many of you probably are, remember that what you are asked to do is to incorporate milestone 1 and milestone 2 into your final project. Now, if you've done a really good job on both of those milestones, you can kind of lift them whole and make them be part of your final project. Many of you will have had some suggestions from me and feedback on the text of your milestones and in the feedback in the grading as to what you should do to improve it. Please incorporate that feedback and those suggestions into your milestones before you use them in your final project. Now, the final project is not just milestone 1 plus milestone 2 equals final project. It isn't that simple. It's just that those milestones have given you a leg up on the project itself, on how to begin it, how to make it be responsive to the entire final project assignment. Now I'm going to stop lecturing you on the final project. I know you're adults and you know how to do this, but I really, really don't want you to miss the opportunity to address all the elements of the rubric. This week, we're taking a quantum leap out of criminal law and into civil litigation, which is a very different animal, really, from criminal procedure, from criminal litigation. It has a different object entirely. In a criminal case, the object of the prosecution, the side that brings the criminal charge, representing the people, the object of a criminal prosecution is to determine the guilt or the innocence of the defendant, and if the defendant is found guilty, to punish him or her. That is the object of criminal litigation. It is not at all the object of civil litigation. The object of civil litigation, which is litigation between two private parties, is compensation for harm that the plaintiff has suffered, presumably at the hands of the defendant. It is the plaintiff's burden of proof that to prove that the defendant caused whatever harm the plaintiff has suffered. The plaintiff has the burden of proving that. Just as in criminal litigation, the prosecution has the burden of proving the guilt of the defendant. The burden of proof always falls on the person who brings the matter to the court's attention, whether that's the prosecution in a criminal case or the plaintiff in a civil case. So let's talk about the terminology. In a civil case, the person who brings the lawsuit is called the plaintiff, and I've explained all this in my written announcement as well. And of course, it's in your written materials. The person against whom, now here's the confusing part, the person against whom civil litigation is brought is called, ta-da, the defendant, just like in a criminal case. So for some reason, we like to use one term in multiple ways in the law. I think it's just to confuse people. But whatever the reason is, we do it. So you've got to respect that and remember that defendant in the civil sense means the person against whom a lawsuit is brought. But the plaintiff is not trying to prove that defendant's guilt about anything. Instead, the plaintiff is trying to prove that the defendant is liable to the plaintiff for the damages the plaintiff has suffered. Now, when you're in law school and you're studying this, the phrase that is bandied about is that the court in a civil suit is trying to make the plaintiff whole again. Well, obviously, we're not talking about wizardry or magic here. The court is not able to wave a wand and make the plaintiff whole again or turn the clock back to before whatever harm has occurred. Instead, the law is limited in its ability to make the plaintiff whole. It's limited to trying to reduce the plaintiff's harm to a dollar value. So, for instance, let's say the plaintiff the defendant has caused the plaintiff to fall down and break a leg. And the plaintiff has had to undergo surgery to set the leg and has had to wear a cast and has had to go through physical therapy, has lost a month or two of work, has been unable to earn money, etc., etc. So the harm that the plaintiff has suffered consists of more than just loss of money, but the law is limited to reducing that harm to a dollar amount because, well, what else can it do? It can't unbreak the leg. So what happens is that the plaintiff and the plaintiff's lawyers and other experts have to try to put a dollar value on what the plaintiff has suffered, and you sue for that amount plus, whatever expenses you have had to undergo as well. So it might consist of medical expenses and physical therapy expenses, how many wages have been, how much in terms of wages have been lost, how much time, how much the family has suffered because you've got one person who isn't able to participate in family events. All kinds of things go into calculating what the amount of damages might be, but it's always going to have to be reduced, except in some specialized kinds of civil suits. The damages always have to be reduced to a dollar amount. That's an artificial construct, obviously, but it's all that can be done. So that you break your leg, you lose 2 months of work. Let's say you undergo or you are now liable for thousands of dollars in medical expenses. What do you do about that? Well, you ask the person who's responsible to pay those things to you. That's called liability and damages. And that is the object of a civil litigation. Civil litigation usually falls into one or sometimes more than one of three categories. Torts, which are civil wrongs between private parties. Be careful with torts, and I've said this in my written announcement, because torts very often look very much like crimes, and in fact sometimes they are. Sometimes the same action, the same event, can give rise to both criminal charges and civil litigation. The second category is contracts. You know what a contract is? It's a legally enforceable agreement between two persons. And person in the law can also include partnerships, corporations, limited liability companies, etc. And the third category we're really not going to spend any time on because we don't have time. It's very specialized. It's called strict liability torts. And strict liability, torts. Strict liability involves a couple of different things, either ultra-hazardous activities that no matter how hard you try cannot be made completely safe, or products liability. Defective products so that the consumer buys something that looks like it's perfectly fine and will work perfectly well, but it turns out that there's some kind of defect in the manufacturing that ends up causing harm to the plaintiff. These are called strict liability, and that's really all I'm going to say about that, because that's a topic in and of itself, and we really don't have the time, and maybe you don't even have the interest in discovering that in this course. And speaking of discovery, a little segue. That's the topic of our discussion board this week, the process of civil discovery. We talked a little bit, sort of, about discovery in a criminal case. We didn't really talk about that much, but some of your reading materials discussed it. In a civil case, discovery is extremely important. The vast majority, over 98%, of civil cases that are filed never come to trial. They are settled before a trial occurs. And the reason they can be settled in a fair and just way, which we hope is what will happen, is that the parties, both parties, plaintiff and defendant, have engaged in a process called discovery, which is the process of finding out as much about your own side of a case and the other party's side of the case before trial as you possibly can. And there are several vehicles through which you can do that kind of discovery process. You're going to read about those in your readings for this week. I'm almost at 12 minutes here on this video, so I'm not going to go into those details. But I have talked about them in a little bit of detail in my written announcement, and your written materials go into even more. Your discussion board asks you to think about the whole discovery process, learn a little bit about it, and then state your opinion as to whether you think wide-ranging discovery that takes a lot of time and goes into a lot of detail, is a good thing or a bad thing in terms of both producing an ultimately just result and in terms of maintaining judicial efficiency. Efficiency has been sort of the order of the day in our last few weeks of discussion, and we're continuing that just a little bit in our civil litigation discussion. Now, I am really going to be quiet now because it's at 12:48 in terms of the length of this video, which is a record for me, I think. So, bye. Have a great week.